As you are listening to our podcast, please remember we are not giving legal advice. This is for informational purposes only. If you need an attorney to help you, please reach out to an attorney within your jurisdiction. May it please the court. My name is Rwan Saffarini Hardesty, and together with my co-counsel Jason Larman, we represent The Appeal of It, a podcast designed to distill Texas Supreme Court opinions, Texas Court of Appeals opinions, and other Texas law to make it all more appealing. Hi, my name is Rwan, and I'm here with my co-host Jason. We wanted to introduce ourselves as our episode 0 and let everybody know exactly what this podcast is designed to do. I've been practicing as an attorney here in Texas for approximately 13 years. I graduated from SMU Dedman School of Law in 2009. I went to school with Jason, and we decided to use our knowledge and expertise to talk to this audience about appeals. I started off my career in civil litigation, and then I moved a little bit into family law, and I've been practicing in family law for about 10 years now. I own my own law firm, and I have been moving towards doing more and more appeals. In fact, I've done civil appeals and family law appeals since the beginning of my career, but at this time, I think that the focus is primarily appeals and then family law as well. My goal in doing this podcast is explaining what an appeal looks like from beginning to end, and then also talking to all of you about what specific cases mean and what they could potentially mean for people in family law, or even if we decide to do some civil cases, what it would mean to somebody in the civil realm. Today's episode, after Jason introduces himself, will be about kind of talking about the whole process in and of itself, and then maybe also talking about some of the words that we'll run across as we're going through each of our episodes in the future. So Jason, are you ready to introduce yourself?
My name's Jason Larman, and I also graduated from SMU Dedman School of Law. I graduated in 2010, and from there I started working with a couple of different prosecutors' offices, eventually landed down near Houston in a division where I was primarily focused on appeals. And during that time I got to work on sort of a variety of different cases in a different world of the criminal stuff, but it allowed me to gain a lot of experience very quickly. And so I was able to deal with a lot of the different post-conviction processes and become sort of a resource in that realm, and then was able to obtain board certification in an area called criminal appellate, which means that my specialty is in fact appeals in the criminal context. Since that time I've left the DA's office, and I sort of split my time between sort of private practice in the legal field and working privately for a company that does construction work. With that, sort of get to navigate sort of business owner and small business type legal challenges, both as an attorney and as a client in a way. And so I can relate to a lot of that and have been through a lot of that, but then also do criminal appeals and then sometimes get pulled into some other things along the way.
Right. And what he's referring to is we have vastly different writing styles, and what appeals really what an appeal really is writing primarily. And so when I write something, I ask Jason to read it and edit it, which he loves to attack my writing quite significantly in many different ways. And same vice versa. If he has an appeal that he needs review on, typically I'll do the same for him. He also gets pulled into trials with me when I end up having to go to trial and need an appellate attorney's mind sitting next to me. So that is a field, family law is a field that he is learning with a lot of hesitation.
Family law is messy, but I think part of the reason we wanted to do this is one of the things that I think we've both noticed over the years is that the two areas where people are most likely to impact the legal field are family law and criminal law. Either that's through family members or through their own sort of lived experiences. And they quite often come into those without any real foundation to know where things are starting and where things are going. And so a lot of the questions that I think we run into, both with new clients and just sort of out in the world talking with other people, is that there's very little out there to help people get a handle on how the legal process works in those contexts, but especially one step removed in the appeals process, where we sort of get past where even a lot of attorneys are comfortable really explaining things because they don't have a lot of experience there as well.
Right. So I think what we want to do is start where most people know and have seen, either through, Law and Order or crime shows or other TV shows where you've got some sort of litigation. Everybody starts with, a lawsuit is filed, and then eventually there is a trial. So there's a lot of intermediary steps between there. We're not here to discuss any of that. But typically, once we get to an actual trial, then that kind of kicks off the potential for an appeal. So there are two types of trials. There's what we would consider a bench trial, which is trying the case to only a judge. So the judge would be a trier of fact and the trier of law, or the person that deals with the law issues that may come up. And then we've got a jury trial, where the judge is dealing with all of the law issues, and then the jury is dealing with all of the fact issues, and they make their decision based off of the facts.
And if that sounds complicated,
it does.
It's because it is. And in fact, one of the things that quite often gets litigated on appeal is when that line gets blurred and the jury's asked to do something based on the law, or the judge is doing something that's based on the fact that should have been left to the jury. That distinction can be a tricky one to navigate.
Once we get to that point, once there's a decision that's been made by either a judge or the jury or both, then what happens next?
So that's when you get to sort of the post-judgment or the post-conviction process. There's a little bit of difference between them, but the basic components are that you have an opportunity to file a motion for a new trial. And in civil, they've got a few other sort of specialized motions that we don't deal with on the criminal stuff. But then you file a notice of appeal, and that's where that process sort of gets kicked off. And the primary purpose of an appeal, and this is a question I think I get a lot, and maybe you do too, is what is the difference between an appeal and a trial? And I think one of the big differences is once you finish the trial, it's sort of everything's closed. There's no opportunity to bring in new information. You don't get to just keep bringing up new things. The purpose of the appeal is to review the conduct that happened at the trial, review whether the evidence was sufficient to support the outcome, whether the trial court's decisions to admit or exclude evidence or things like that were appropriate. All of that factors into whether the trial was performed correctly, but it's not an opportunity to continue to bring in new evidence and new things like that.
Right. There is the potential to bring in new evidence, but that's on the motion for new trial issue, if there is new evidence.
Yes, and to clarify that, the motion for new trial is an opportunity to do that. That's a procedure that happens in the trial court. Mm-hmm. And then after that is when you move into the appellate courts, and then kind of get into that process where it's based on, court reporters' transcripts and the exhibits that were admitted and things like that.
Right. So everybody knows that a trial is quite expensive, especially if you go to a jury trial, because it's usually multiple days. You've got a lot of attorney's fees. You've got, all the paper that needs to be prepared, everything. So, but people don't think about the fact that appeals are equally as expensive, because we have not only the trial transcript, which is the court reporter's transcript, you also need all of the clerk's records, which, we can pick and choose the documents that we want, but typically if the appellate attorney wasn't the trial attorney, which happens quite often and is probably a better option for a lot of people, then they really need to deep dive into all of the pieces that occurred throughout the trial or prior to the trial as well, because in some instances we don't know all of the facts. And sometimes we need to just kind of figure out exactly what happened and if there were judge changes or ruling changes and things like that, because that could also inform us as to where we ended up at the trial level. Let's talk a little bit about what happens when we have filed the notice of appeal. The next step is we request that reporter's record and the clerk's record.
Right. Yeah. So the next step, and this I think is probably frustrating from the outside, is that appeals are a very slow process, right? Quite often you've been sometimes years in the making to get to a trial. And then as soon as you get to the trial, now you're on what in a lot of instances is an even slower timeline, because you have a period of time where the clerk is preparing all the documents and getting that stuff packaged together. And then the next deadline is the court reporter. And the court reporter, depending on how long it took, it may take quite a while to go through and compile all of that and confirm that it's correct and everything else. And sometimes the courts of appeals get frustrated with how long the court reporters take. And so we'll see, sort of snarky letters from the courts of appeals,
right,
letting them know that they really need to get it done.
I have a case like that right now.
But then once the record is complete and you've got the clerk's record and you've got the reporter's record, that's when the work really begins. Because at that point, somebody needs to go through and sort of digest all of the information that's there, identify the points of error, the things that you're going to complain about, and then compile what's called a brief, which is basically just our written arguments about where mistakes were made, or on the other side, where mistakes were not made or were not significant, in order to sort of allow the Court of Appeals to fairly evaluate what happened at the trial.
And I think that we might have skipped a little bit as to why somebody would bring an appeal. So typically it's a person that lost at trial or feels that they lost something at trial. That would be the person bringing the appeal. And they would be called the appellant. They're the ones that kind of kick off that notice of appeal process and start requesting all of the things. And then some people call the person that's responding to the appeal the appellee. Mm-hmm. That's how we say it. I'm sure a lot of people say it different ways. I know that it was said a bazillion different ways when we were in law school. So, but that's how it's said.
We say things different down here in Texas. And so sometimes the ones that practice in Texas don't know how the rest of the world pronounces things.
Right.
But
what Jason was alluding to with the reporter's record, when we have trials, some trials, if you think about some of the trials that have been televised or live streamed on various podcasts or news outlets, some trials take 3-4 weeks and some take as little as 2 hours. So the 2-hour trials, we can get a reporter's record very quickly, but anything more than 3 or 4 days, it's going to take them time, especially because there's going to be a lot of exhibits to compile, and they literally have to transcribe everything because court reporters they're typing in shorthand, so it all has to be transcribed into longhand for those of us that don't know how to read shorthand.
Well, and accuracy is the other part of it, right? We want to make sure that what they do type in shorthand and then that gets transitioned over, which a lot can be done with software in real time, is accurate. And so it's very common for them to also have an audio recording that they can sort of go back and listen to if there's something that they're not sure that they got correct when they were typing it out in real time and things like that. And in fact, I've had cases where there was a particular phrase that there were questions about. And so once it got to the Court of Appeals and there were questions about whether it was accurate, they actually sent it back for the court and the parties to listen to the audio recording and sort of all sign off that it was said the way that it was said, because there was just a lot of uncertainty about whether the trial court had said what the transcript said they said.
Right. In one of my cases currently, and that's where we have a the Court of Appeals was slightly upset at the court reporter, and everything is fine now, but it took her approximately 5 months to get us a record, which has also now made it more difficult for the appellant, because the appellant is now on a shortened leash by the Court of Appeals. And so the Court of Appeals has already said we're not granting many extensions in this case.
We've already run out of patients.
Right. So once we get the record and the clerk's record and the appellate attorney is reviewing everything, that's when the timeline really starts for the appellate attorney. So typically here in Texas, what happens is once the later of the two records gets basically published to the Court of Appeals or filed to the Court of Appeals, it's usually the reporter's record, then the appellant has 30 days to file their brief. It's almost impossible to do that.
It's rare.
Right. And so typically that first 30 days, an appellate attorney is reviewing the records, is trying to distill all that information, trying to figure out where those points of error that Jason was talking about are. And sometimes they're having to call the client as well and say, what did this line of questioning mean? Or call the trial attorney and say, what did this line of questioning mean? And what did these answers mean? Because sometimes they're very vague. If you're at the 30-day mark, you can ask for extensions, which is why the process seems slower. Typically, the Court of Appeals will grant two or three extensions, depending on the case.
Yeah, I mean,
so each extension is 30 days long. So that kicks you out anywhere from 60 to 90 days after it's taken the clerk's record and the reporter's record to come in. So,
and I think where you're going with that is after that attorney finishes their work, then the clock starts for the attorney for the other side, mm-hmm. and they get sort of the same grace of 30 days with the ability to extend it. And then once that happens, then the court suddenly has their time, and they've got varying workloads depending on the complexity of the case. It may have to get sort of shelved for a little while they sort of clear enough time to really focus on it and things like that. And so what happens in a trial is that everybody's there at the same time and it all happens simultaneously. But on an appeal, it's very asynchronous. You have one person working on their step and nobody else is doing their step until that person finishes. And so it's a very drawn out process because you have step one and then you wait to start step two until step one is finished. And then you wait to start step three until step two is finished. And so it seems like it takes a long time, even though no one person is necessarily taking that much time on their own. None of the steps can happen at the same time because each one is responding to the step before them.
Let's say that the appellant has filed their brief. The reason that the appellee, which is the person responding, can't really start their step is because they don't necessarily know what the issues the appellant is going to bring forward are. So when they read a record, say that they've received the record, because they will receive the record at the same time the appellant receives the record. But they may read it without looking for responses to what the issues will be that are brought up by the appellant are until
Sure.
the appellant has drafted their brief.
And especially in like a criminal case where it's a very black and white question, you know, is the person guilty or they're not guilty?
Right.
The outcome is one thing, but typically what you have is you have a defendant who's now complaining about steps that happened at their trial. And until you're specific about what those complaints are, there's really nothing to respond to. So you typically have one side saying, here was a mistake that was made at trial, and the side who is happy with the outcome either saying that it wasn't a mistake or it wasn't a big deal. And so, or it wouldn't have affected the outcome if we hadn't made that mistake or whatever. So until the specific complaints have been lodged, there's really nothing to respond to.
So the brief is what is written. That's what we submit to the court. It's like a big essay explaining to the court what the law is and how the facts of the case apply to the law and where the errors may have been during the trial court's jurisdiction and during the trial. Then once all of the briefs are in, so the appellant has drafted their brief, The appellee has drafted their brief. The appellant may respond with a reply brief if they want to. It's not necessary in every case, but they're able to do so. Once all of those pieces are in, then the court itself will set their schedule and hopefully give you a decision at some point. The longest decision that I have had is 2 years.
Okay.
So
I've had several go over a year, but.
And really, like Jason was saying, it depends on their docket. And sometimes there are courts of appeals that are so overwhelmed that they'll actually send some of their cases to another court of appeals to decide because they just simply don't have the bandwidth to do it. Sometimes you're just sitting and waiting and the client is in your ear asking where the decision is, and all you can say is, we're just waiting. Eventually the Court of Appeals will send a letter when they're ready to hear your case that says, we have impaneled our justices for your case, and we plan on hearing it within some period of time. Once they've impaneled, they don't necessarily give you a date unless you have asked for oral argument. So let's talk a little bit about what oral argument looks like, or what it means when you've asked for it.
Probably the closest analogy would be closing arguments in a trial, right? It's basically an opportunity to summarize the law, summarize the evidence, present the arguments that are the most relevant to your case, and help the Court of Appeals understand where their focus should be. And the difference between it and, I guess, a closing argument is the Court of Appeals can ask questions. So you may come in thinking, well, this is what we're going to talk about, and you may be surprised that that's not what the Court of Appeals wants to talk about. And so it's very important that you sort of have a marshal of sort of all of the case. I can remember at one point it was a capital murder case we were arguing where the defendant had raised like 13 different complaints, which is a lot for a case on appeal. But we only had 20 minutes to discuss it for each side. And so there was sort of a moment of reflection on, okay, what specifically is the court wanting us to talk about? And to nobody's real surprise, they were very quick to point out, hey, these are the specific things that we really want to hear more about. And so we were able to focus on those issues and sort of flesh out the law and the facts as it applied to those. But the basic answer is that it's a conversation with the court. And so you have an opportunity to sort of answer the court's questions and sort of help them look at things in sort of through the same lens that you are, so that hopefully, if you've done your job correctly, they'll at least understand your position.
Right. And it's a persuasive argument to the court, essentially. When you're answering their questions, you're trying to persuade them to your side and explain that the law actually fits your side better than the other side's. The thing about that is you don't know what the court is going to ask you until you're literally in front of them. They aren't going to send you a letter that says, well, usually they're not going to send you a letter that says, we're going to ask you questions about these specific issues. Right. And so you really have to prepare. If you have a 13-point brief, a 13-issue brief, you have to prepare all 13 issues going in and know your case 100% inside and out. And then once you get there, you can do that culling process. On the prosecutor side, it was easier for you because typically the prosecutors are the responding party. They really don't, the state doesn't typically bring their own appeals. It's usually the defendant that's bringing their appeal. And in oral argument itself, it's the appellant that goes first. And so they get asked all of the questions first on the fly. So the appellee is able to kind of distill during that first 20 minutes and see exactly what they need to ask or what they need to answer. And it's a better position to be in sometimes, but you were the person that won at the lower court anyways. So it really is all about the appellant trying to persuade the court to go their way and change the ruling. from the other court. Now, how can they change the rulings? What can an appellate court say? They've listened to everything, and now they're going to issue their opinion. And so the opinion looks like another brief, another big written document.
Yeah, we get their essay submission at that point.
Right.
But theirs carries a little more weight than the rest of us. I mean, the basic options typically in front of a court of appeals are that they can affirm the trial court, which is we're leaving the trial court's rulings in place. They can reverse the trial court and remand, which means we send it back to the trial court essentially with instructions on how to try again and do it better the second time. And then we get reverse and render, which is where they basically take away the trial court's even responsibility to enter a judgment and do that. And the most obvious context where that happens is if the evidence, say you've got a criminal case, the evidence is not legally sufficient for that person to have been convicted because of double jeopardy protections and things like that. You can't just try again. So in that context, the Court of Appeals would just order that they have been acquitted, and they might send that back to the trial court to do the paperwork, but there's no discretion on the trial court's part to kind of decide where to go from there. They just give the instruction that this is what you're going to do now.
Right. And so that instruction is the rendering portion of their opinion. Typically on the civil side and the family law side, they will reverse and remand to a new trial, and then you kind of have to redo everything if that's the way that it goes, which then adds a whole layer of expense to everybody again. And
I think the other part of that difference, and I think I kind of alluded to this earlier, in a criminal case, you basically have two questions that get answered. And one is the person guilty or not guilty? And two is, what's the appropriate punishment? And that's pretty much it. But on a civil case, you can have any number of different questions that are asked, and those questions can all independently be incorporated into the judgment and then independently decided in terms of the appeal as to whether those particular things were appropriate.
Right. And sometimes the court may affirm parts of a decision and, reverse and remand another part, or, there could be a slew of different things that could occur on the civil side. And so it may be that they affirm a portion of it and they want, so in a family case, they may affirm all of the possession and access portions of it. The parties are allowed to have the same possession and access that the trial court decided on. But there's a child support issue as well. So they may reverse on the child support issue and ask the court to redo that part of the trial, which is a smaller section than having to do the whole trial again. It's a big rabbit hole when we get into the civil side. The criminal side is a little bit more cut and dry, thankfully for Jason. I wanted us to kind of turn a little bit to what it means when there are concurrences and dissents as well within a opinion. So typically what happens is you get an opinion. So in a court of appeal, you get a panel of 3 judges typically. And those 3 judges will hear the case. They'll read all the briefs. If there's oral argument, they'll listen to the oral argument, and then they'll issue their opinion. Now, there will be one justice that will write the opinion, and the other 2 will either basically agree with what's written, or they will potentially write their own portions of the opinion as well, which could be considered a concurrence or a dissent. So what's a concurrence?
There's typically a majority opinion, and especially when you get to the bigger courts with sort of more people weighing in on a particular matter, you'll see it more often. But essentially, you'll have the opinion that controls the case, right? Which in the Court of Appeals setting would be the one that has basically 2 votes in support of it. Right. A concurring opinion would be an opinion that agrees with the outcome, but doesn't necessarily agree with the path they took to get there. And then a dissenting opinion would be a justice that disagrees with the outcome overall. And the reason that's important and the reason that that happens is because that gives insight into the way the judges are getting to their conclusions, because those will then be used to analogize other situations in the future.
Right.
And that information can be very useful for the court to have out there so that people have a better understanding of where the judges' heads are and where they're likely to end up. But it also gives more guidance so that they can then use that case to then build when the next case comes up and things like that.
The thing about appeals is typically the court of appeals, whichever court of appeals is dealing with the case, is only deciding a very discrete portion of the case or of a situation. And so when Jason is talking about building on with other cases, there are facts that may occur in one case that don't occur in this first case that they have decided. And there may be a justice that is thinking about, well, what if this other thing happened? How would we deal with that situation if it were presented to us? And that's what the concurring opinions will or even the dissent opinions can do for us, is kind of give us a little bit of foreshadowing as to what that court may think on new issues that haven't quite presented themselves yet.
And I think where a lot of people have probably run into that is the Supreme Court opinions, right? It's very common, especially given sort of the noted polarity between the two sides at the Supreme Court level right now. It's very common to have a very solid unit of justices or judges at that level that feel one way, and then a very solid block of judges that feel another way.
So I want to caveat this with our podcast will not be political in any way. We are going to steer as far away from politics as we can. Sometimes we do have to talk about some issues, but we will keep that very neutral and non-polarizing.
And where I was going with that is what you'll see is one side of sort of those two blocks will write an opinion that will be a majority opinion, and that will be the one that becomes the law of the land. But you'll have a dissenting opinion, especially these days. You'll quite often have a dissenting opinion, and a lot of what that dissenting opinion will do is it will sort of criticize that argument or point out things that argument overlooks. And that's sort of an opportunity for the judges to do that, because that assists everybody else in knowing sort of where the limits of that reasoning are.
So now we've got we've got an opinion, we've got potential concurrence, we've got a potential dissent. What happens next? Does anything happen next? Or does the appellant just say, let's say the appellant doesn't win?
Well, somebody's going to get an outcome they like better than the
Sure.
other side. So typically what happens at that point is there's an opportunity to have a higher court review it. So on the criminal case, it would be the Court of Criminal Appeals here in Texas. On a civil case or a family law case or things like that, it would go to the Texas Supreme Court.
But before we get there, we can ask for a rehearing, right?
You want to go to that level of detail? Okay. Yes. You can ask the court to reconsider. So that would be through a motion for rehearing. One of the other options is the motion for rehearing en banc,
right,
which is asking, instead of it being the 3 judges that heard your case, you're asking that it be all the judges. And in some instances, the Court of Appeals, where a lot of my cases used to go, had at the time 4 justices.
Right.
Which meant that if you had a vote that was 2 against 1, and you got a hearing en banc, it meant that you had one wild card judge that could sort of weigh in on it, and so it was rarely effective. But a lot of the bigger courts, even here in Texas, at the same level, some of the Dallas and Houston and some of those have significantly more judges. I think some of them have 9 or so.
9, yeah.
Which means that now you go from having 2 judges against 1 judge to there being 8 or 9 judges that are all going to weigh in. And so it can potentially upset kind of the whole outcome of it by just having more eyes looking at the case.
Right. Once we get an opinion at that point, then we can go on to a higher court review if that's what one of the parties chooses to do. Because remember, we've got a situation where they may have reversed you back to trial, and it may be more beneficial to ask the Supreme Court to potentially hear it first before going all the way back and retrying the issue. How do we get to the Texas Supreme Court or the Texas Court of Criminal Appeals once we've received a decision from the Court of Appeals?
So both the Texas Supreme Court and the Texas Court of Criminal Appeals are what's considered discretionary courts. And well, I guess the U.S. Supreme Court is too, where to get to the Court of Appeals, all you have to do is ask to be there. And the Court of Appeals will hear your case and they will review it.
Right. They have no choice.
Right. That's basically automatic when you ask. The discretionary courts, the ones sort of the layer above that, only hear the cases that they want to hear. And so the way you do that is you file what's called a petition for discretionary review, where basically you set out sort of the situation in your case and you ask them to hear your case for reasons typically bigger than your own case. You know, the most effective ones are the ones that sort of point out, hey, if we continue to do it this way, here's where this will lead us, or this is a significant issue, not just for my case, but for sort of the state as a whole.
Right.
But it's that mechanism, the petition for discretionary review, that gives you an opportunity to sort of present that in sort of a truncated form, just to give them the main points on why they should hear your case. And then if they do, that's when the briefing process starts all over again. Now you're submitting a brief, not necessarily complaining about what the trial court had done, but now you're complaining about what the Court of Appeals chose to do, right, which may be layered in with what the trial court had done. But ultimately, you're asking them to correct a decision of the Court of Appeals at this point, and they may or may not choose to do that.
At that point, like Jason kind of briefly stated, you're really talking more policy and the way that this could hurt more people than just this one party. A situation where there's a current case that is pending the Supreme Court's decision, whether they're even going to, the Texas Supreme Court's decision as to whether they're going to take the case it's a family law case. One of the firms that I am well acquainted with is trying to discuss how financial records are dealt with in family law cases and what actually needs to be presented to the court and how and whether an expert opinion's decision affects that and how that would affect it. And that would, once that decision is made, if the Texas Supreme Court takes it, it may ripple through the family law community as to how we actually present evidence at trial as a whole rather than just in this specific case. Typically, that case is based off of high value assets, and it's really important that we know what is sufficient to get the correct result when we're splitting assets, because that's ultimately what we do in family laws. We split assets and kind of split children. So, or how time with children is split, I think is the best way to say that. If the Supreme Court, the Texas Supreme Court, or the U.S. Supreme Court, or the Texas Court of Criminal Appeals takes the case, we brief it. Oral argument could be requested as well. Yes. Oral argument can be granted. And then the same thing, the appellant, it could flip at that point. Who is the appellant and the appellant?
The person who's appealing the trial court's decision might be perfectly happy with the outcome at the Court of Appeals, and so now it's the other person who's now asking to sort of go back to the way it started.
Right. Yeah.
And you may have been the one complaining the first time and the one saying everything's fine at the second stage.
Right. Or it could be that the trial or the appellate court affirmed the trial court, and so it's the same appellant.
You're still complaining.
Right, so you're still complaining. So then that opinion will be issued, and then are we done?
Practically speaking, yes, that's the end of the line. There's, depending on what the issues are, some issues can be taken again on a discretionary basis to the U.S. Supreme Court. it takes a lot of stars to align for the Supreme Court to take an interest in your case, because it needs to be something of basically constitutional importance. Mm-hmm. And especially in the family law context and in the criminal context within Texas courts, you're typically dealing with Texas law issues. And so unless there's a Texas law issue that somehow sort of steps on the toes of a federal constitutional issue, it's rarely of interest to them.
Right. That's when it would kind of fall into more of a political realm, depending on what each of the courts are deciding federally and locally as well. Now there are circuit courts as well. We are a part of the Fifth Circuit Court of Appeals. How is that interlaced in all of this, or do you not have a good answer for that?
No, because that's a question that I get from people just kind of walking around, especially when they see headlines about, the Ninth Circuit or the Fifth Circuit or, whatever. So the circuit courts are effectively the federal system's courts of appeals. So when we say the Court of Appeals, we're typically talking about the Texas state court level. The circuit courts are the regional courts for the federal system. So you'd have sort of a state district court that would go to a state court of appeals and then a state Supreme Court. And then on the federal side, you'd have a federal district court, a federal circuit court, and then the federal Supreme Court of the U.S. Supreme Court. And that would sort of be the chain that those go. And then what we were talking about before is that when you hit sort of the ceiling on the state court side, there's sort of an avenue to get those issues reviewed by the federal Supreme Court. But there's not a lot of overlap between them other than that, except when dealing with some very specific constitutional issues.
Just really quick, I think that people hear a lot about what is an amicus curiae, because especially when we get into the Supreme Court issues, we do it in Texas. There are a lot of amicus briefs that are filed in Texas.
Amicus brief is probably the phrase most people have encountered. So an amicus brief is a brief where somebody who's not a party, right? If mom and dad are fighting, or the state and a defendant are fighting, it's not either of them. But for example, especially on the criminal side, there's a lot of sort of extrapolation that can be of concern. So if there's a particular set of facts where that sort of creates ripples outside of that particular case, it's not unusual to have either another attorney or a nonprofit or an organization that has a vested interest in seeing the law sort of develop or mature a certain way to come in and try and shed some light from another perspective. Mm-hmm. And so an amicus brief is basically a brief written by a friend of the court. So you can basically ask permission to come in, sort of have your voice heard as well, sort of as an extra bit of commentary on sort of the potential. It's a good opportunity for those people doing them to sort of point out the broader view, right? So a defendant is going to be very focused on why their case should be decided a particular way and how it impacts that defendant. But those organizations that bring an amicus brief, especially at the higher levels, it's sort of unusual at just the Court of Appeals level, will come in and sort of provide that different perspective of, if you decide this particular defendant's case this way, here's the way that's going to impact other defendants in the future. Right. One of the questions that I encounter a lot, especially being more criminal focused, is, everybody knows that like you can appeal it. But I think a lot of people don't realize that when you do appeal it, you're limited to the facts in the case. You're limited to the evidence that was presented at trial. And so if you find a confession from somebody for the same crime that you didn't know about during the trial, the Court of Appeals is not the destination for that information. There's a separate sort of collateral process that runs parallel to it that we really don't have time to get into today. But that's where you quite often see death penalty cases take so long to litigate, because the direct appeal process, where it bounces just through the standard sort of hierarchy we talked about, that process doesn't take 20 years. But it's all of the sort of side litigation that can come in through some other channels that is the reason that those cases tend to take so long.
And then I think from the civil side, once we get to a certain point, it is up to the parties as to whether they want to continue moving forward in processes, or if, there have been cases that I have been a part of where you're in the appeals process and you may be concerned about what the decision may be, or you are just completely unsure what way it may go. And so you could actually potentially settle the case post-trial while you're pending appeal, because we're talking about money damages or, again, family issues. We were talking about child support issues or possession and access. And these are all things that while we're sitting waiting can actually bring about some sort of consensus between the parties. So, if we're concerned that child support is off by $100, we may be able to kind of split the baby and come up with an agreement while the appellate process is going through, and then we would dismiss the appeal at that point as well. There are multiple avenues that appeals can go through. That's one of the reasons that we're here. We want to make sure that as we are going through cases in our future podcasts and our future episodes, that, if you feel overwhelmed by the terms, hopefully you can come back to this one and we can help distill it, or you can kind of go see what the process is. But we'll also be working on, explaining more terms as we come up to them, because when we read cases, when we're reading briefs or we're reading opinions, all of a sudden there may be a new term that comes up that one of us is like, what does this mean? And how is that going to affect our case? And then we'll read it and we'll say, well, this is what this does for us, or this is what it would do for this other party. We hope that this was informative, and
I appreciate you being here with us.
Yeah. So we'll talk to you later. Bye. As you are listening to our podcast, please remember we are not giving legal advice. This is for informational purposes only. If you need an attorney to help you, please reach out to an attorney within your jurisdiction.